to this next session of the World Arbitration Update. And we here at Kroll are very happy to be hosting this interesting panel, and I'm sure we'll all have a lot to learn today. For those of you who have been joining us all week, this is the third day of sessions. We've been at The Hague and Mexico and Singapore, and we still have Bogota, I believe, if I got the order of events correct. But thank you again for joining us, and I will turn things over to Jose Antonio.
Thank you, Ashley, and I would like to thank in a very strong manner Kroll and Mooring for supporting and sponsoring Washington World Arbitration Update, and I would also like to say thanks to our panelists, especially because I know that they made a big effort to join us in Washington, D.C. from Asia, specifically from China, from South Asia, and last not least, and perhaps the most important, I would like to emphasize that the World Arbitration Update is a forum that has two objectives. One is to decentralize international arbitration. And by decentralization, we mean that there's incredible counsel and arbitrators and experts that are not necessarily in the main centers of international arbitration, Paris, London, New York, even Washington, D.C., but they may be in South America, in Asia, in Pakistan, in China, etc., in India, in Eastern Europe, and so on and so forth. And what we're trying to do with the World Arbitration Update is allowing everyone in the 5 continents to have access to those experts and wonderful arbitration specialists. And with that, an important aspect of World Arbitration Update is it is free of cost for any attendees, either in person or online. And we also are building a library of this panel so that people will have access to this information later on. And with that, the panels will stay in time and will not be ephemeral. In addition, the World Arbitration Update is a forum that has as a second objective, and also very important, to update on issues of international commercial and investment arbitration and public international law. With that, it is with great pleasure that I am introducing Momin Mohsen, who is an associate at Strategy, a boutique firm in Washington, D.C. and Bogota, which we created 5 years ago. And Momin has actually a dual degree, both from the United Kingdom and from the United States, and he is qualified to practice in Washington, D.C. And he's a remarkable lawyer, and of course, with his background and being from Pakistan, follows all the issues related to South Asia, among other things, in his interest in public international and international arbitration. I believe that you could not be in better hands, and therefore welcome you to this panel. And from here on, Momin will introduce everyone else. So very glad to have this panel on, which is one of our hallmark panels. Thank you.
Good morning, everyone, and thank you, Jose Antonio, for that lovely introduction. It is my pleasure to extend a very warm welcome to all of you to the second panel of the World Arbitration Update DC edition. Our panel today is titled Exploring the China-Pakistan Economic Corridor, Unraveling Infrastructure and Energy Disputes, Opportunities, Challenges, and What Lies Ahead. As Jose Antonio mentioned, the World Arbitration Update seeks to connect diverse regions with the global arbitration community. Its mission is to decentralize and expand the dialogue around international arbitration and public international law. By bringing the China-Pakistan Economic Corridor, or commonly referred to as CPEC, into this forum, we aim to continue that mission by spotlighting a region rich with investment, legal complexity, and emerging opportunities for arbitrators and counsel alike. CPEC represents one of the most ambitious and multifaceted infrastructure initiatives in modern times. It not only reshapes the economic and geopolitical relationships across Asia, but also brings with it a host of legal questions. And this panel will delve into the evolving dispute resolution landscape around CPEC, while also considering the broader implication for cross-border investment. Joining us today are a panel of experts, some who have quite literally traveled from across the globe to be a part of this important conversation. Seated to my immediate left is Mia Shiraz Javed, our presenter for the panel. Shiraz is a civil engineer turned English barrister who specializes in construction and energy law. He serves as an arbitrator, a mediator, an adjudicator, and a dispute board member. He works with number 5 barristers' chambers in the UK and holds the rights to practice in Pakistan, the Dubai International Financial Center Courts, the Singapore International Commercial Court, and the Astana International Financial Center. Shiraz is the founding chair of the Pakistani branch of the Chartered Institute of Arbitrators, the Society of Construction Law Pakistan, and the TCC ADR Center. He represents the Dispute Resolution Board Foundation in Pakistan and trains professionals globally in mediation, arbitration, and adjudication. We also have with us Junji Wang. Junji is the founding partner of Globe Law Firm, and he serves as an arbitrator for several institutions, including CTAC, BSc, CIAC, and HKIC. With 22 years of experience in commercial dispute resolution and 15 years as an arbitrator, he primarily provides dispute resolution services for Chinese enterprises and multinational companies operating in China. He has also served as the chief editor and has published several reports, including those on intellectual property index, intellectual property arbitration, and legal issues concerning China time-honored brands. We also have with us Dr. Nudrat Piracha. Dr. Piracha is a solicitor advocate of England and Wales, an international arbitration expert with over 20 years of experience, a Fulbright scholar, a senior international JAMS fellow, and a fellow of the CIARP UK. She has acted in high-stakes disputes under ICSID, ICC, CIAC, and DIAC rules. She has represented both states and investors and served on the ICSID annulment committee. She also regularly sits as an arbitrator. Widely regarded for her thought leadership in investor-state arbitrations and harmonizing dispute resolution systems, she continues to shape legal policy and treaty frameworks. Finally, we have Richard Deutsch. Rich is an experienced international arbitrator who works with clients around the world, guiding industry leaders through complex commercial and investor-state disputes. He has led cases under the rules of major arbitral institutions like the ICTR, ICC, CIAC, HKIC, and ICSID, as well as ad hoc arbitrations under UNCITRAL rules. Recently, Rich has represented investors in high-stakes treaty claims against the governments of Colombia, Guyana, and an Asian nation. On the commercial side, he has handled disputes for a major Swiss pharmaceutical company and has been involved in fraud-related cases spanning China and Germany. Recognized as a top lawyer in his field, Rich was named the 2023 Lawyer of the Year for International Commercial Arbitration by Best Lawyers in America. In addition to his legal practice, he has been teaching international arbitration for over 10 years at the University of Texas School of Law, and also lectures in Switzerland as part of the University of St. Gallen's Executive Master of Business Law program. He is licensed to practice in both Texas and New York. Now, to set the stage and provide us with a comprehensive overview of what CPEC is, how it has evolved, and perhaps more importantly, why it matters, it is my pleasure to hand over the floor to Shiraz.
Thank you very much, Momin, for the kind words. The primary idea for today's presentation is to introduce this part of the world with China-Pakistan Economic Corridor. Probably we might have heard about NEOM, which is considered to be the biggest development project initiated by the government of Saudi Arabia. But what most of us does not know is probably CPEC, or China-Pakistan Economic Corridor, is the second largest project of that part of the world after NEOM. So just to give you an overview, this China-Pakistan Economic Corridor is being developed as a flagship project of the Belt and Road initiative by the government of China. It was started with an initial investment of $46 billion, which has now surpassed $100 billion, mainly the infrastructure and the power and energy projects which are being built up in Pakistan. And this eventually leads to the to Gwadar port. Gwadar is the port city of Pakistan, on the shores of which you can see the lights of Port Dubai. And I will come down later on to the exact geographical map of where China lies and what exactly is the benefit of China coming down to and developing this whole road. CPEC, since it is, we call it the economic corridor, it is the road corridor, almost parallel to the Silk Route, which was there for thousands of years. And despite the challenges like the COVID-19 delays and all that, it remains a main focus by the government of China. We are now entering to CPEC 2, but before I come down to that, I will give you an overview of what is the significance of CPEC. So this is going to give the economic and trade boost for both the countries, since China is considered to be the largest exporter of the world, and for its connectivity to have its goods being transported in the minimum amount of time. And this is where this China-Pakistan Economic Corridor comes in. In terms of the foreign investment, it is the largest FDI that Pakistan has ever received. And in terms of legal and arbitration opportunities, since it is a project of $100 billion, most of the contracts are FIDIC Red Book and Silver Book. And people who are from the construction industry, they understand that they have got a multi-tier dispute resolution clause, which is why they're the arbitration opportunities, dispute board members, and such other opportunities, they are also there. Disputes can be handled in Singapore, London, Hong Kong. But the new world is now shifting from the United Kingdom to Singapore, and now we can see things might shift to Dubai, Abu Dhabi, or Qatar, depending on how these disputes will be handled. So in terms of the project, this is the project table. You can have access to these projects from cpec.gov.pk. We have got 21 projects in the energy sector, 4 projects in terms of transport and infrastructure, and then we have got 8 projects in the city Gwadar. For transport and infrastructure, we have got, they're developing 1,700 kilometers of road, which is going to connect Xinjiang, the province in China, to all the way down to Gwadar. So it involves roads and involves railways, the Karakoram Highway, M5, M9. All these details, they are available at the cpec.gov.pk website. In terms of energy, they're developing renewable energy, coal, and they're laying down the transmission lines, what we call is Mitiari to Lahore transmission line. They've got a solar park in Lahore, then Daud Wind Power Project. So all these details, I don't want to name the projects, but they're all available under the cpec.government energy site. And these are the projects which are being established in Port City Gwadar. So this is what my main slide is going to be. If we may see here, China is developing most of its goods from Xinjiang province, which they have to travel almost 3,500 kilometers in order to reach to the Chinese Ocean. And from once they're there at the Chinese Ocean, it takes for them between 45 days to 51 days, all the way coming down from here, going if they want to go to the Middle East. And then if they are able to get something from the province of Xinjiang coming down here to Gwadar. So this was what the idea was. This is 1,700 kilometers. This is a little more than 3,500 kilometers. So instead of going all the way 3,500 kilometers from here to there, and then 45 to 51 days, all the way coming down to the Middle East. Now, if you can develop a road between Xinjiang coming down to Gwadar, so, and if it is 1,700 kilometers, you're saving almost half of the road travel from 3,500 kilometers to 1,700 kilometers. That is a huge saving in terms of the road travel. And then, all this distance taking a lot of time, almost around 1.5 months, from China coming down to Middle East. But then if you're in Gwadar, you are right in the middle of Middle East, which means you can navigate yourself anywhere, any part of Middle East in just 3 days. And then going on to the Europe is the next destination that you can take. So when you come down to all this situation, you can see that government of China has plans to actually reduce the time from the road travel of 3,500 kilometers and that 45 days. You can very well imagine the amount of money they are going to save from this shortage of time plus that road travel that they are doing, and in terms of the sea travel as well. So this is the starting of CPEC. So we call it CPEC 1, which involves the development phase, and then CPEC 2, where they have got 3 industrial states on this side of the motorway, where they are mindful of having, so it's almost around 2,000 acres of each industrial zone. These industrial zones, along with Port City Gwadar, they will be under the, so Port City Gwadar has already been declared as tax holiday for next 40 years. And for these industrial zones, they are EPZs or special economic zones, depending upon what status the government is going to give to them. They're going to have these 3 industrial states as their first defense line, second defense line, the third defense line in terms of the economic goods. So they are going to have the raw material being exported to this first place, where they are going to have a little bit of assembling of the material, sending it to the second one, where the further assembly is going to take place, and then Port City Gwadar, where they have got the final goods, or maybe the last process of assembling of the goods. So once they're done with that, they can send down their goods to all these parts of the world, and so this was the basic understanding that initiated the China-Pakistan Economic Corridor. The way this is being performed is most of the contracts, they are being given to MCC China, which is working as the main contractor to this whole China-Pakistan Economic Corridor. And then we have got 70% of the contracts being subcontracted to the Pakistani contractors. So primarily there's a contract between MCC China or the main contractors from China with the subcontractors of Pakistan through FIDIC Red Book and FIDIC Silver Book. All of them, they have dispute resolution clause, the dispute resolution forum, ICC, that has been mentioned as their dispute resolution forum, where all these cases, all these matters are going to be adjudicated. Starting from 2016, 2025 is the year when we are going to see these arbitrations being popped up. And this is what we are here for, to elaborate before the arbitration community in this part of the world, that we need neutral nationals for the adjudication of these matters. So I'll finish up my presentation here, and I'll pass it on to Momin so that we can have the second presenter for this one.
Thank you so much, Shiraz. One key takeaway from your presentation, at least for me, is that if there's one thing lawyers are great at spotting, it is an opportunity, especially when it's dressed up as a cross-border infrastructure dispute. But building up on that foundation, we now shift our focus from the ground realities of CPEC to the broader legal and institutional landscape shaping investment protection, particularly from China's perspective. And for that, Junji, you have the floor.
Thank you. Thank you, Momin. Good morning, everyone. I think our speaker just gave us a wonderful presentation. working? Thank you. I think our panelists just gave us a wonderful presentation about the topic about CPEC. As you all see that this project is very ambitious. They present significant opportunities for economic growth and regional connectivity. Of course, it also faces multifaceted challenges, including disputes over infrastructure development, energy projects, and geopolitical tensions. I think that's why we are here today. We come together to discuss both opportunity presented by this project, CPEC, and the challenges and the disputes. I don't want to spend too much time in this session at the moment. I want to have the panelists' comments as well. Then we'll accept your questions and comments. Oh, yeah, is it now for me to introduce the rules or later on?
You can do that right now. Yeah.
Oh, I can do it now. Good. Yes, as scheduled, I want to share some very interesting developments about the BIT's investment arbitration and so on. Up to now, China has signed 147 BITs, of which 110 have entered into force. Also, as you may know, China signed and ratified the Exit Convention in Washington on February 9, 1990, and has been a member state since the date of signing. They are over, this is also very interesting. They are, yes, sure. I just, yes. Yes, so now you can see my screen. There are over 200 arbitration institutions in China. Among them, 5, maybe less than 10 are quite active and famous in the world. CPEC is one of them. CPEC made its international, what they call international investment dispute arbitration rule almost 10 years ago, and that's 2017. The rules are designed to recognize both investment treaty arbitration and investor-state arbitration contractually agreed by the parties. The transparency issue, the CPEC rule provides the hearing must be public unless the parties agree or the tribunal decides otherwise. This is interesting. This contrasts with the exit rules. which says differently about this transparency issue. The CPEC rule also provides for the publication of words and documents relating to the proceedings other than confidential information, and unless the parties agree otherwise. This is also different from the exit rule. So you can see CPEC wants make its own rule. The efficiency issue, CPEC rule also includes features about early dismiss of a claim or a counterclaim on the basis that it's manifest without legal merit. That's generally the highlights about the CPEC rule. CPEC investment arbitration rule, which came into effect almost 10 years ago. The other one, what we call BAC, is one of the largest in China. It's quite well known around the world. Beijing Arbitration Commission. This institution also made its rule in 2019. In BAC's rules, they adopt the new mechanism. We can call it a new parallel mechanism. This is the first arbitral institution in China to introduce such procedure in investment arbitration rules. In Asia Pacific region, neither SIAC nor CPEC incorporate such procedure in their rules. We can look at the exit rules. Exit rules also do not permit exit examining any substantive issues of an arbitral world. So this new appellate mechanism may encourage parties to bring the claim before the institution and choose the BAC rules. Of course, BAC also tries to balance the confidentiality with transparency. The rule provides that any recordings, transcripts, and documents associated with the arbitral proceedings should remain confidential unless parties have agreed that a hearing should be conducted in public. There are other considerations with CPEC rules. I don't think we will spend too much time on this part. I also want to take a quick look at the other major arbitral institution in China, like SCIA. Many of you know this institution too. In SCIA rules, they don't have specific rules for investment arbitration. They simply said, well, its current rule can be used for a case like investment arbitration. Similar, this one is based in Shanghai, what we call as SHIAC, SHAC, Shanghai International Arbitration Center. Similar procedure for them. So you may see in China, the major arbitration institutions trying hard to get attention from the field. They want to, of course, at the moment there is no case in front of these institutions, but we do have a lot of cases. For example, China is a respondent state. There are cases here. As you can see, most cases are still pending. We don't know what's going on. Sometimes we only know a few of these cases. As respondent state, sometimes China can win on the jurisdiction issues. You can see all these cases here. Let's take a quick look at this. Of course, China also is a home state of a claimant. There are also cases too. The cases of investment treaty arbitration involved China so far. There are also some cases here. Let me just show you quickly, so you may see all of these cases here. We're still waiting for the result of these cases. They will, if we have a chance, we will discuss this with you later. I think that's all for my view and presentation here. Thank you.
Thank you so much for those valuable insights. Rich, moving on to you. You have the floor.
Thank you. And thank you everybody for participating here. This is a fascinating panel and I'm honored to be a part of it. As you saw in one of my colleagues' presentations, there was a heavy slant towards energy projects, which is interesting. And he can maybe provide more background, but energy was not why China got into this. This was a corridor, literally a corridor for the reasons he explained, to avoid going all the way around and just going straight through and enhance trade. And Pakistan really pushed the energy perspective on it. And because there were, like many countries, and we've seen this before in the past, they needed to upgrade their facilities, they needed to draw investment in different matters. And so that's how that sort of became part of the package. So the way I like to look at these things, and it's probably part of your all's practice or things that you've seen. I really like to look at this from the investor's perspective. So this is a painting from an American artist from the 1800s, Thomas Cole. He was a romanticist. He has some religious overtones, but it doesn't really dominate it. It's always telling a story. And if you look really closely at this, what this is a series of photos. It's called The Course of an Empire. There's 5 paintings in it, and it starts out, it shows you sort of the lifespan of an empire from the beginning all the way to when it falls apart. So what you look at here, though, is the investor, while you and I, if we don't have any interest in this, saying, oh, look at this beautiful land, and look at this, the resource must be beautiful, where you and I may focus on the trees or the cloud coverage or even the water in the background, the investor, the foreign investor, is thinking about financing and getting approval from the banks and risk. And in many situations, their job and career can be on the line for certain investments. And what they're looking at is that boulder on top of the mountain in the background. Because what's going to tip that boulder over to fall and make everything collapse and make your investment fall apart? And as the series of these go on, and I'm not going to go through all 5 paintings. You guys can do it with your spouses at date night or something. But as it goes on, that boulder is always there. No matter what's happening below it, it's always there. So it's sort of like what's hanging over you. And that's sort of the investor's perspective, right? Like, what are some of the things that the investors are looking at? And so what they're going to look at is pretty similar. What's the investment environment in this region now after this agreement? And as you've seen, there's a huge, like China has I think a $521 billion energy portfolio there. So there's a lot of activity in that area. So the way it works for the power generation, this scenario I'm going to set up. Any of you who have been doing any energy work or just investor state arbitration for the last 20 years are going to be sort of familiar with this structure. Maybe not in this part of the world, but so they basically want to upgrade their facilities instead of, whereas other countries just straight out privatized their different utilities in different sectors. What happened here is the energy was going to be produced by independent power producers. So not going to be government entities. You're going to draw foreign investment, and they were going to sign these contracts with them. These contracts, you would expect it to sort of be like the purchase and share contracts or purchase and share agreements that we've all seen in different cases. This is sort of like that, but it's got some really interesting twists that we'll get to in a minute. Anyway, it was a struggle at first. I mean, these projects were put out to bid, did not draw instant investors. And most of the NSC explained before, like everything else, a lot of the plants were China owned, and then it went back through the country. So one of the biggest factors that has occurred, and it's a big problem that's arose from these contracts, is they have a capacity payment requirement. And again, you may remember capacity payments from prior disputes in Latin America way back, and it's come up in different scenarios. A capacity payment, and probably the best way it can be explained, is basically the power generator is going to get paid every month, no matter how much power they generate. The idea is to incentivize them to always keep a certain amount of power ready when it's needed. But there's a downside to that, and that's what sort of has occurred here. And here's how one report put it. The contracts with the independent power producers, which include capacity payments, add to the circular debt in Pakistan's power sector. Capacity payments, which are fixed payments made to power producers, whether or not the electricity is used, have cost Pakistan up to $540 million a month. Some power plants in Pakistan have received capacity payments despite generating zero power. So that you can see where that could frighten off some investors and cause some hesitation. There's also, if you are an investor in it, there's no commitment on the buyer to buy a certain amount. So, you're pretty much relying on those capacity payments, because what do you do? And you can't take it out into the market. It's not a right of first refusal. So you can see the problems it's going to all cause. But the downside for Pakistan is that they end up having to pay a lot of the bills, because these are just unpaid to keep it going. And the big problem is not so much they can't come up with power generation. It's just, among other reasons, there's a really inefficient distribution system, which is not unusual in the situation where they're trying to restart the system. Investors have complained about lengthy permitting process and frequent regulatory changes. So these are all things that investors are looking at in the back that could maybe push that boulder over. And then, of course, we can't really avoid, and hey, we're in Washington, D.C., so why not discuss it, the numerous geopolitical factors. Look at all the countries involved in this particular scenario. First, you've got the China angle, the obvious one. Well, China was a big driver in this, but lately, a lot of their investment has been moving a little bit elsewhere, like everyone else. I mean, remember at the time this was signed, it was a different world. Now, China's interests are sort of going out elsewhere. They're looking not so much at energy like traditional. They're moving towards the metals and the chemical. And yeah, because for chips and all the value in that. And that's not in Pakistan right now. That's in certain parts of Africa and the Middle East. And you've got countries like Indonesia, which is touting their minerals. So now, is an unstable situation getting worse because the primary investor is focused on something else. So that's one factor to think of. And then India. So, they're not always worried about security. And this, of course, predates the attacks recently. It's been a tumultuous relationship, to say the least. And making it even more of a challenge between the countries is, while Pakistan's dealt with different issues, India has put done a lot to secure foreign investment there, including a lot of high-profile infrastructure
Pero sí
projects.
entiendo, porque si no me dejas sin permiso. Sí.
Jose Antonio, I think you're unmuted.
And then you've got, keeping on the geopolitical topic, you've got the US factor. As you may or may not be aware, the current administration and China are not getting along right now. So how does that affect everything? How does that affect, the investor if you're worried about that? And maybe if you're a US investor, you're worried, I don't know if I should be doing this. Are there going to be tariffs? If I structure another way, do I have to worry about the government over my shoulder? So you've got that whole thing. And then you've got the other factor is, overall security in Pakistan. It's a nuclear nation, and that also draws concerns from the neighbors and from the US. So there's a lot of factors that they're thinking of. And there's been some unsettling behavior. I mean, what investors are seeing is recent reports. I think there was one that an offer was made by Pakistan to China that one of the ports that was going to be built that would be done in return, China would help them boost their nuclear defense capacities. So those are the kind of things investors hear, and it makes them think that Boulder's about to fall. So let's take it to the next step. Now you're the investor and you're in that boat. This is another painting by Cole. It's called Voyage of Life. And it takes you through 4 stages of life. And the beginning one, childhood, is, a child on this boat coming off of floating down the river. It's all bright and there's an angel waving to it. The second one is it's still really bright, but you can sort of see some rough waters coming. This is the third slide. This is adult. And what you're seeing here is someone floating down the river. They're not even holding onto the tiller. It's out of control. They can see a precipice that they can't escape from. So second step, the investor is going to look at it and say, okay, now I know what could push off that boulder. What would happen if indeed that happened? And I'm going to be there. I don't want to be stuck in this situation. So, of course, when it's rudderless, the idea is that international arbitration will maybe get you to shore safely, right? Because international arbitration, whether it's commercial or investor state, you've got protection against commercial risks and political risks. That's the purpose of it. And so let's just see sort of what's out there right now for foreign investors in the energy industry there. So the first thing we do is we turn to the arbitration clause in the contract. So it's pretty interesting from an academic perspective. It can be a little concerning for the foreign investor, but it's a multi-tiered investment provision. So, we're first trying to see that the parties resolve it amicably. And there's an option to go to an expert determination first. And if the expert does not make his determination by a certain time, they can go on to arbitration. And none of that is really that unusual. But it's interesting because some of the contracts include matters that must go to expert determination. You can't take it. You don't have the arbitration option first. You have to go to expert determination. And the expert determination is often binding. The matters that must go to expert determination, some of these contracts include force majeure, which is a huge part of any international energy contract, or payment disputes, which is probably the other half of most international energy contracts. So that could raise alarm that you have to rely on an expert determination, which is binding even if you go to arbitration. Then for arbitration, it directs you to LCIA arbitration. But here's the catch. First, it's LCIA arbitration by one arbitrator. I think for disputes that are going to be this large, I think you'd want to have more than one, and the parties would probably agree to that. But they was probably thinking about smaller disputes. Second, if for any reason the dispute cannot be settled pursuant to the LCIA rules, the dispute shall be finally settled by the UNCITRAL trial rules by one arbitrator. So you could end up in UNCITRAL trial rules arbitration. The arbitration is either going to be in Pakistan if it's under a certain amount, or if it's over $7 million, then it's seated in London. It's interesting, they have a provision here that says, and if the LCIA rules will not work because they will not result in an enforceable award in the Pakistan courts, then you go to, then it moves to Pakistan. I've never seen that before. In other words, meaning one way or another, the LCIA rules are somehow going to be not enforceable, or a court's going to rule that it's not, it violates public policy, or for whatever reason, then it resorts to arbitration in law. I mean, then you end up going to arbitration in Pakistan. So it's a really unique provision. I've heard about it. I've never really seen that before. You've got the changing of the seats, although there's disputes about whether maybe it's, even though the seat can't be in Pakistan because the amount is over 7 million, London doesn't become the official seat. And they've had court decisions about that. It may be settled, but that's a very troubling perspective to not know what seat you're going to end up in, because ultimately that's where the award could be vacated. There's a really interesting clause that basically puts the LCI rules of the arbitration will have precedent over anything, over bit arbitration provisions. I don't even know if that's enforceable or that would matter, because it's two separate things. You got a breach of a contract and a breach of a treaty. So there's some really interesting language in here, which you can say can be manipulated with and make things really troubling. There's also a sovereign immunity provision, but it's limited to certain assets. So that's something to really pay attention of. And finally, what about the bits? Pakistan, as we all know, is signatory to about 40 bits. They've been involved in numerous bit claims, so this is nothing new to them. The cases are pretty typical of what you've seen in other cases, and their primary defense a lot has been corruption by the investors. It's interesting because I don't know, you can have this interplay between bits and the arbitration clauses. That's a double protection. We always talk about how these arbitration provisions are there to protect the investor. I don't know how much people are relying on these, but I think the counsel for them in advance is going to be giving them a lot of really serious advice that should be considered. So I've gone over my time. Thank you.
Thank you so much for those valuable insights. Earlier, Shiraz briefly touched on the dispute resolution clauses in CPEC contracts. Now, picking up on that thread, but with a more critical lens, we turn to Dr. Paracha. Dr. Paracha, I believe you have concerns about the lack of standardization in these clauses.
Thank you so much. I couldn't agree more with what my colleagues have said, and especially the importance of effective dispute resolution clauses for the investor and the states. So my focus is on a subject which is often ignored, that is the legal and institutional backbone that underpins these massive infrastructure and energy projects. So CPEC is not just a corridor of commerce, it is a corridor of collaboration. The BRI countries, I feel, share a common culture and legal sensibilities, values of respect, negotiation, long-term relationships. And this makes them ideal for a dialogue-based solution. BRI countries also, I feel, share their unique set of challenges: limited legal and institutional capacity, poorly negotiated contracts, ambiguous dispute resolution clauses, evolving sovereign policies, political instability, financial constraints of many of the BRI states, and security concerns. These factors result in uncertainty, especially in EPC and O&M agreements, tariff regimes, execution, implementation, and legal mechanisms. So the existing CPEC framework, of course, the contractual framework that was referred to by my colleague, it's fragmented. Similarly, the BIT regime in Pakistan, while Pakistan did decide to opt out of the bilateral investment treaties, it does have a bilateral investment treaty with China. That was in 1989. The new FTA is an improvement on the bilateral investment treaty. Just 1 second, I think my screen is frozen. I just need 1 second. Sorry about that. So China's own bilateral investment treaties, they are the old treaties. They were very conservative in providing rights to the investors, but the new treaties, they are much more generous. But what is alarming is many of them, especially with the BRI states, do not have a ISDS clause, which means they will not be able to go to ICSID or another international arbitration forum. So amongst the legal remedies, China has some special courts. In Pakistan, we have seen emergence of centers like International Center for Appropriate Dispute Resolution and Prevention. The ad hoc arbitrations are not permitted in China, but in Pakistan, those are the only arbitrations that we have. We do not have model clauses, model laws at the moment. Despite these structural issues and the fragmentation, there is no dedicated CPEC institution to anchor these diverse processes. And there is a lack of standardization in these clauses, as we have just discussed. I think here we can learn immensely from the experience of the World Bank. World Bank, at one time when it was investing in multiple countries which had different cultures, different set of problems, they had to unify and come out with a multilateral framework so that these problems could be addressed. So World Bank in 1960 came out with the Washington Convention, which was a multilateral instrument, bringing all these states as members on board. What the Washington Convention did was to unify the procedures. It unified the seat of arbitration if the parties failed to provide one. It unified the governing law, and it married it to the international law, because it was a realization that in many of these disputes, one of the parties involved is a state. It unified the arbitration institution. In many cases, it was ICSID. Given the changing global relationships, there is a dire need for a system that is cognizant of the global and political sensitivities, and a system that unifies these fragmented systems. We must shift from a reactive to a more proactive model. So in preparing for the future for China, Pakistan, and many of these BRI countries, what I propose as the next steps is a standardized dispute resolution clause, a multilateral treaty framework between Pakistan, China, and the BRI countries, a regional dispute resolution center, and integration between the arbitration mediation centers in the BRI countries. I propose placing mediation at the center of these systems, introducing med-arb clauses because it is very close to the culture in these BRI states, creating a CPEC legal oversight commission, and I propose building legal capacity in key institutions in the BRI states. As a closing thought, the strength of CPEC lies not in the roads and the power plants that it is going to build. It lies in the legal architecture. So let's ensure that CPEC becomes a global model for harmonized, culturally responsive, and future-ready dispute resolution. That is my 2 cents for the future.
Thank you so much. Well, this question is now for the entire panel, and this builds upon Dr. Parash's call for harmonization. Do you see practical pathways or potential obstacles to achieving this greater standardization and institutional coherence?
So I think starting from what Richard started, having a difference of the seat from in Pakistan, whereas then an amount is of certain of certain quantum. Like for example, if it is less than $5 million, the seat is going to be Pakistan. But that all happened in early 2000s. In CPEC, they have used the standard form of contracts, primarily the FIDIC Red Book, the FIDIC Silver Book. And they all come up with the idea of multi-tier dispute resolution clause, starting from party-to-party negotiations in good faith. And if that fails in a specific number of days, then the matter will then be referred to the dispute board. And in 2017 book, dispute boards, when you talk about the DAAB, which is the Dispute Avoidance and Adjudication Board, so that a dispute avoidance board is almost similar or even more efficient than the mediation, because it gives you the dispute avoidance mechanism at the first place. They try to resolve it, and if it fails, then they have they can change their hat to dispute review board, which can give a binding decision, binding but not final. And then you've got the arbitration into the dispute resolution clause. So I think in terms of harmonization, if you are using the FIDIC Red Book and Silver Book, they are pretty harmonized. Like they have got the same standard dispute resolution clauses. In terms of that bilateral investment treaties, I think the contract, you cannot contract out BIT, but that is a totally separate thing, because people who have been into that international commercial arbitration, even after losing the arbitration or right in the middle of arbitration, they realize they've got a BIT, which is signed between their the investors' home state and the investment state, where the investor is putting on their investment. So when realizing about the BIT, they had the option to opt for the BIT, which actually takes them to exit if they qualify for the definition of investment. So for that regard, I think mediation, I don't know why the construction center, they are not too fond of using mediation, because probably they have developed the creature, what we call as the adjudication. And then they have also added up a new feature of dispute avoidance board in that. So this is what my 2 cents are in terms of harmonization of the dispute resolution clause for CPEC. And the idea of having these disputes being adjudicated in Pakistan or in China, I'm not sure whether a party can be its own judge on that principle. You can take up these cases to China or to Pakistan. Although in international arbitration, there is this trend. If one of the parties is not from that domicile, you can start the international arbitration in any of these places. But in order to have that, these clauses should have been agreed with not just with Pakistan, but also with other BRI states. But what we see is at the time of choosing FIDIC Red Book and Silver Book, probably both the parties, they were not aware of what dispute resolution clause they are signing up with. And now when these disputes are about to erupt, based on my personal experience, these investors are coming down and asking for, so we signed up for ICC, and how does this ICC work? So ICC is in Paris, and whether we have to go to Paris because it's a civil law jurisdiction and we are common law, and how things will work. But then ICC is mindful of sending down these disputes to maybe ICC Abu Dhabi or ICC Singapore, which is going to be the nearest part. But all these things, one is about the awareness or the education of the parties. On one side, it's Pakistani subcontractors. And on the other side is the Chinese state-owned MCC China, which is acting as the main contractor. So these two elements I just wanted to highlight in terms of the harmonization of the dispute resolution clauses.
Are you optimistic that they could actually, the parties could sort of agree on a uniform resolution system? Everybody.
I do think with the experience as I narrated of ICSID, it is possible to come to a multilateral arrangement between these states. And just to answer to something Miyashira said, FIDIC is, of course, a standardized form of contract. But when we look at dispute resolution clauses, of course, there is the part 2 of the FIDIC contracts that parties usually end up changing in the construction contracts. And I can share from my personal experience that the second part contains usually an alteration in the dispute resolution clause. And many of the cases in Pakistan, there has been no arbitration between the Chinese party and Pakistan. But one of the arbitrations that we are dealing with by one of the subcontractors of the Chinese party, there was a modification to the dispute resolution clause in the second part of the contract. And it has taken, before we were appointed, 12 years under the 1940 Arbitration Act of Pakistan for appointment of an umpire. That alteration in the clauses, the dispute resolution, that does happen. And many of these contracts have been altered to read 1940 Arbitration of Pakistan. And the clause that was shared by Richard, that is the clause that comes from the wind projects and many of the energy projects that the firm is currently working on. So that is very much a live clause, and there is no standardization in those projects, energy projects. So just having FIDIC, yes, it's standardized provisions. It's a very good start. But for dispute resolution clauses, I'm afraid it is not really helping Pakistan or China.
Thank you so much. Junji, do you have any comments?
Yeah, I think I agree with my analyst by saying, well, it's actually a party's will to solve disputes. The more case I handle, the more I realize this is really a complicated issue. The parties, most time, maybe all the time, parties are smarter than their lawyers. They know what they want. They know what they want to achieve through these articles, contracts, even treaties. But sometimes lawyers don't. What lawyers argue mainly they always focus on the legal concepts, legal jargons sometimes. But for the parties, there's always one thing clear, that is the contract interest, whether they can get what they want, they understand it. So I mean, for the dispute resolution mechanism, we are still on the way. We still don't know what is the perfect model for the current situations. We need to keep working.
Thank you so much. We're just almost out of time, but I have to address the elephant in the room. There are reports that Beijing is slowing down CPEC projects and is less interested than it was 10 years ago. How do you think that will impact the future of the project generally, and do you expect more disputes to come out of it? Yeah, so I said there are reports that Beijing is slowing down CPEC projects, and how do you think that will impact the future of the project?
In terms of, I still couldn't understand the impact that you're talking about from Beijing.
Yeah, so American newspapers have reported that CPEC has been slowed down, and China is less interested in carrying out with like future CPEC projects.
So I'm not sure. I'm not the right person to comment on if the China-Pakistan economic corridor was slowed down. There are certain other elements which are also involved with that part of the world, not in just in terms of the political element, but also in terms of the predictability and delivery of the project. But I think that CPEC has been it's almost more than double now. It started with $46 billion. It is now more than $100 billion, which means the projects are constantly being added up in that CPEC, which means that the government of China is not too, that they have not felt that it has been slowed down. Rather, they have constantly been adding a number of projects into it. And now we can see CPEC 2.0 is now coming up. Which also means that if that is what the case of, or maybe the situation by Beijing is, probably CPEC 2.0 would have not been discussed, or no. Now we are about to see that these 2,000 acres each, we are going to have between 3 to 6 industrial states. The places that are being handed over to the government of China, where they are going to have their industries being in place right on that corridor, on that motorway. So I think this is not exactly the case. There can be a slowdown. We have had the COVID year as well. So after the COVID year, 2020 and then 2021, things could have been taken up in that regard as well.
Rich, do you have any comments?
I mean, I've seen those reports as well, and I think in the context of what I was referring to, I mean, those are the kind of reports that investors see. And as far as whether we think they're accurate or not, I think the point is just that's the impression people have. Then all efforts have to be made to change that impression. And I think highlighting certain successes, as my colleague pointed out, about huge amount of projects that have been done, those are the sort of things that need to be highlighted. But in the reports, those don't ever come out. So there may be a messaging issue that has to change.
Just to give an idea on that, I don't know, CPEC has not been promoted like the way it should have promoted. Most of even the big law firms in China, when I was out in China and in Beijing and Shanghai, these firms have no idea or no clue the size of the investment that has been poured in by the government of China in CPEC. So that is what the situation in China is. And when we go out of Pakistan, in Middle East, in Europe, and in the continent of America, I think most of the people I've met, they don't know about the exact size of that $100 billion. Wow, this is too big an investment, which is going on in Pakistan at the moment. So I think this is where we are lacking in here. We have not properly promoted it, branded it, or marketed it out to the world, which is why all these confusions of slowing down, probably things are not right, because we don't see any such a campaign that has been taken up by either government of China or government of Pakistan about what exactly the state of the situation or where we are right at the moment and how much time is left in terms of the development. That 1,700 kilometers is about to finish. Probably 1,500 kilometers plus is finished, is completed. It's just 150 kilometers worth of road, which is already in the development. They've got an airport at Gwadar almost settled down. They have done their testing. So all these things, they have not been brought before the before the international community. I think which is where this whole situation is lacking.
Any final words from our other panelists?
Just for the factual accuracy, Shiraz is quite right. There has been a lot of investment and a lot of work has been done. In Pakistan, to my knowledge, where I have seen things stalled or things slow down, there would be, for instance, the payments to the IPPs. It's about 2.3 billion that is owed to the Chinese power producers. The problem there is the financial constraints of the country. Similarly, the main line, the railway upgrade project, that's another one, $6.8 billion worth of project that has been stalled again because of financial uncertainties. So I think the main recurring theme that comes out times and again is because of governance issues in the country. And those are things which, of course, are risks that the investor build into their contracts, and there are ways around those issues when the investors invest in countries like Pakistan. So there are things that can be overcome.
Right, thank you so much. Well, with that, we're out of time. Please join me in giving a big round of applause to our outstanding panelists for their thoughtful insights and engaging discussion. So before we wrap up, I want to extend a few sincere thank yous. First, a big thank you to Kroll for so graciously hosting us. Ian and Jose Antonio, thank you for the trust and opportunity to moderate the session. Events like these, especially when coordinated across continents in the span of a single week, require an incredible amount of work behind the scenes. And I want to recognize my colleagues at Ed Strategy, in particular my colleague Maria, or Mats as I call her, for her tireless dedication and her sharp coordination in driving this initiative forward. I also want to thank my former colleague, Maria Camilla, who's joining us online. Her continued support and encouragement has meant a great personal deal to me. And of course, we're not done with the World Arbitration Update 2025 quite yet. Tomorrow, we continue with a full day of panels in Colombia. So unless you've managed to snag a seat on the newly gifted Air Force One, your best option is to register online and join us virtually. We will be thrilled to have you there. Thank you so much.
Thank you, Momin, and let me say again thank you to all of you, just by name, Dr. Piracha and Richard and Shengxi and of course Shiraz. Thank you for being here. And one of the elements of World Arbitration Update is that yes, they may be seeing you at the other side of the world, but in addition to that, we have this sessions recorded and we're building a library so that this becomes information for experts and for counsel and for arbitrators, etc. So we really thank you for being part of the World Arbitration Update, and the next session will be tomorrow in the morning, the Americas time. Okay, thank you.